I'm talking to Jeremy Sirrell, partner at Palmer's Solicitors and specialist in motoring offences. Jeremy, I'd like to talk to you about drink driving offences specifically. So what are the current drink driving limits for breath, blood and urine?
Okay, well the limit in breath is currently 35 micrograms of alcohol in 100 millilitres of breath. In blood it's 80 milligrams of alcohol in 100 millilitres of blood, and in urine it's 107 milligrams in 100 millilitres of urine. But in relation to breath, I should also mention that although the legal limit is 35 micrograms, the prosecutable limit is 40. That is to say that if you give a reading of between 35 and 39, you should not be prosecuted. Only if you give a reading at 40 and above will you be subject to prosecution.
So what kinds of offences are there?
Okay, there are essentially 4 different kinds of offences of this type. The first are offences of driving whilst unfit, and these are offences committed when people are unfit to drive through drink or drugs, but there is no laboratory specimen confirming exactly what their reading is. These charges are now quite rare, but they still do occur from time to time. The second type of offence is straightforwardly driving with excess alcohol, and driving with excess alcohol means driving with alcohol above the prescribed limit, whether it's breath, blood or urine. And if your breath, blood or urine is above the limit prescribed by law, then you have committed the offence, subject to the offences that you might want to raise. The third type of offence is of failing to provide laboratory specimens. That is to say, when you've been asked to provide a specimen, whether it's breath, blood or urine, if you fail to provide those without reasonable excuse, then that's an offence itself, and it's quite separate and dealt with separately. The fourth category of offence is quite interesting, and that's the offence of being in charge of a motor vehicle with excess alcohol. And that offence arises where somebody has greater than the prescribed level of alcohol in their body, and at the time of being discovered by the police, or it's normally being discovered by the police in their car, at that time they were in the car or in some way in charge of the car. It's an interesting offence for a variety of reasons, including, amongst others, that there is a statutory defence that if you can show the court that you would not have driven whilst you are still in excess of the limit, then that's a defence to the charge. So they're the 4 different kinds of offences, broadly speaking.
So taking that into consideration, what kind of penalties are in place for motorists that are caught drink driving?
Essentially, minimum penalties in terms of disqualification will be a year's disqualification for a first-time offence. For a second-time offence within 10 years, the minimum disqualification increases to 3 years disqualification. There is no maximum disqualification period, and it should be noted that minimum periods of disqualification are reserved for those at the bottom end of the scale of offences. So if you're twice the limit, or you've been involved in a collision or something of that kind, you will not escape with a minimum period of disqualification. It may be significantly longer. In terms of financial penalty, the maximum fine is £5,000, and in terms of imprisonment, the maximum sentence of imprisonment is 6 months imprisonment.
So are there any special reasons that can be used when you're defending a drink driving case?
Yes, there are special reasons, and the question is quite properly put. Strictly speaking, you need to divide it into 2 parts, because there are defences as such, and there are also special reasons, and they're slightly different. Let me explain. A defence to driving with excess alcohol might be post-driving consumption of alcohol. And an example of this might be someone has had a pint of beer in the pub, they've been driving home, they've been involved in an accident which may not be their fault at all. Some kindly neighbour has taken them in, and because they're in shock, they've given them a double brandy. All very helpful until the police turn up and then breathalyse them and find that they're over the limit. Now, if it can be shown to the court that but for the double brandy or whatever it is that they had, they would not have been over the limit, then that could be a defence to the charge, because at the time of driving, their body would have had less than the prescribed limit of alcohol in it. So that's a clear defence. Now contrast that with what's often referred to as the spiked drinks defence. Now this is a circumstance where somebody they may have gone out to a party, may have gone out to a pub, what have you, and some helpful individual has slipped double vodka into their orange juice, and as a result they're over the limit and may be stopped on the way home and subsequently may discover what has happened days or weeks afterwards. Now, if it can be shown that the additional amount of alcohol which they'd had unwittingly is what's pushed them over the limit, then that's not a defence to the charge, because the charge is driving with excess alcohol, and you've either got excess alcohol in your body or you haven't. But it could be considered by the court a special reason, so that the court does not disqualify you for the offence. So those two are the most common defences. One is a defence proper, one is a special reason. There are other special reasons as well, but I won't go into those in this podcast.
Jeremy, thank you very much.